When Barbara was saying that she was looking at the portrait of Justice Brennan and she was glad to see he was leaning a little bit to the right, I had always thought he was leaning.
I didn't say I was glad. I just made an observation.
Well, my point is I always thought he was leaning left. It's clear that it's a matter of the perspective from which you are looking. Are you looking at it from Brennan's perspective or that of the audience? Framing this issue, as several of my distinguished fellow panelists have, in terms of who's afraid of a runaway or a crazy convention, I think sort of misses the boat, because it assumes we can agree about what a non-runaway convention is. What is this creature? What kinds of state applications, if any? Sandy Levinson thinks you don't need any. Are required to trigger it? Who sets its rules? How do its proposed changes become binding law? Now, some people say that the puzzles are all solved. All you have to do is become your own expert, look at the Federalist Papers, read the text, carefully study 18th century custom and practice. And some of the people who have worked a lot on this have published rather imposing articles with titles like Amending the Constitution by Convention, a complete view of the Founders' Plan. Well, even James Madison, during the Philadelphia Convention, quite famously observed that the Article 5 procedure is dangerously vague. He was sort of an expert, though he didn't have the internet to look things up in. I have to say, it takes more chutzpah than I at least, or should I say chutzpah? It takes more chutzpah than I at least can muster to say, oh no, we've got it all figured out. And it's not as though the unresolved questions about what this creature is are sort of peripheral. I mean, they cut to the very heart of what a new convention is supposed to be and what powers it's supposed to have. And at least 10 such questions seem to me to be really beyond resolution by any generally agreed upon legal or political method. And we just tick them off. May a state application insist that Congress limit the convention's mandate to a single topic or a single amendment? For that matter, if Congress may call a convention independent of state applications, as Sandy Levinson argues it may, then how could state applications possibly constrain the convention's mandate? It seems to me that it couldn't. On the other hand, if applications are constraining, then how are applications proposing related but different topics or amendments to be combined or separated? Suppose they are similar but somewhat different. Do you add them up or do you not add them up? When do you hit the magic number of 2/3? May the convention propose amendments other than those that it was called to consider? May Congress prescribe rules for the convention or limit its powers in any way? And here's a really important one, fundamentally important. May the convention set its own rules independent of Article 5 for how amendments that it proposes may be ratified, the way the Philadelphia Convention did. After all, the Philadelphia Convention was called under a scheme under the Articles that said ratification required unanimity among the states. But they departed from that. A lot of the speakers today have said not to worry. Article 5 says that it takes 38 states to ratify. But what if the convention decides that ratification will be by a national referendum without giving 13 small states a veto power? Certainly, if your idea of a convention is to correct the most fundamental defects in the system, like Sandy Levinson's emphasis in a lot of his writing on the defect that every state has the same number of senators, whether it's a huge state or a small state, it would follow that if you're going to change that, you're going to have to change Article 5 itself, which says that no state can be deprived of its equal suffrage in the Senate without its consent. And if you're going to change that part of Article 5, why not the part of Article 5 that specifies the mode of ratification? Another question, are the states to be equally represented, or does a one-person, one-vote rule apply? And here's a question that could well tie the country in knots for longer than the 18-month running reality show that Sandy Levinson has in mind. What about the District of Columbia? We can't even figure out if the citizens of the district should be able to vote for members of Congress. What's their role in such a convention? Could delegates be bound in advance by legislation or referendum to propose particular amendments or vote in a particular way? Now, if you choose them by lottery, the way Professor Levinson would, it's a little hard to imagine how they could be bound in advance. Could the convention propose amendments by simple majority, or do you need 2/3 or a supermajority? If each state gets one convention vote, must delegates representing a majority of the population nonetheless vote for an amendment in order for it to get proposed? Conversely, if the convention uses a one-person, one-vote formula, must the delegations of 26 states, perhaps including the District of Columbia, nonetheless vote in favor of a proposed amendment? And this is absolutely critical. What role, if any, would the Supreme Court play in resolving conflicts among Congress, state legislatures, governors, referenda, and the convention itself? Barbara assumes, oh yes, we can rely on the court to hold things in check. But can we? The court certainly has assumed that questions about the ratification process are non-justiciable political questions that it can't get involved in. And who would have standing to invoke the court? It's my best guess that the court would stay a million miles away from all of this. Now, there's disagreement not only over the answers to those questions, but over how to go about answering them. It's hardly news that there is deep division, not only on this panel, those who say they're originalists and those, like Sandy Levinson, who say they're not originalists, on the proper methods of legal and constitutional interpretation. Now, Nick pointed out to some laughter in the room, well, this is no more vague than most of the Constitution, and he didn't intend that as a joke. I'm sure he didn't. Fact is, we all know that there's a lot of stuff in the Constitution that is very vague, very ambivalent. And somebody might say, well, so what's new? Article 5 is no different from the Bill of Rights, the word liberty, the commerce power, but there are some fundamental differences.